Molly, thank you so much. It's my pleasure to be here. I never lose an opportunity to pitch our Center for Civil and Human Rights here at Notre Dame. For those of you who don't know about us, we were established in 1973 by Father Ted Hesburgh when he resigned from the U.S. Civil Rights Commission, and he brought his best lawyers and his papers to Notre Dame. And the center's earliest days were really focused on civil rights issues in the 1970s, and then we soon added the "and human rights" to our title and have focused for decades now on human rights issues along with civil rights issues. The best thing we do, and what we're most proud of, is educating human rights lawyers from all over the world. They come to Notre Dame Law School for a one-year master's degree, an LLM degree, in human rights law, and I imagine a number of you have had them in your classes, and I think a few of them are going to be coming to the symposium later today. We have over 350 lawyers from over 90 countries that have been educated in the last almost 30 years as Notre Dame lawyers working on human rights all over the world. So know that you are always welcome to the CCHR events. We're located on the second floor of this building. We also are now part of the new Keough School of Global Affairs at Notre Dame, which should inject a lot of new energy, expertise, and networks into our center's work. For the last couple years, one of our main research themes has been human trafficking. So it's a real pleasure to be able to participate in this seminar this morning, to be co-sponsors of the event, although I have to congratulate the editor-in-chief, Veronica Meffy, and her team for putting on and organizing a really wonderful, exciting morning for us. Just by way of short synopsis of what's going to happen today, the first hour will focus on the Uniform Law Commission's work on human trafficking. The second hour will discuss the uniform law approach more generally, and the morning will wrap up with the keynote lecture by Notre Dame professor Alexandra Levy with the challenging and intriguing title, "Why is Sex Trafficking a Crime?" I hope all of you can stay with us. There will be two breaks, one at 10:30 and one at 11:30 this morning. Also, please feel free to come and go as you need to. I know some people have classes. Feel free to come and sit down close so that we can have a more engaged and intimate exchange. So yes, know that you are welcome to come and go as you need to, and that this morning's symposium will be taped and posted on the Journal's website along with the Center for Civil and Human Rights website, in case you need to miss anything. So the work at the Center for Civil and Human Rights tends to focus on international frameworks for human trafficking, especially the international treaty adopted in 2000, which is called, uses the shorthand, the Palermo Protocol. And its framework, set out in 20 relatively pithy articles, calls for countries around the world to focus on a 3P, we call it the 3P approach to fighting trafficking: the prosecution of traffickers, the protection of victims, and the prevention of trafficking. And the U.S. federal human trafficking law, the 2000 Trafficking Victims Protection Act, or TVPA, and subsequent legislation, follows the same international 3P framework, although it's hardly pithy or concise, as you might imagine. Countries around the world have been struggling, or not struggling enough, or not struggling at all, for 15 years to adapt their national legislation to comply with their treaty obligations under the Palermo Protocol. The results are all over the map, making the hope for a uniform approach, let alone legal consistency or harmonization around best practices, extremely remote at the transnational level. And just as in the international setting, enacting appropriate and effective anti-trafficking laws at the state level in our country is an enormous challenge. And as the ULC report indicates, some states seem to incorporate best practices into their anti-trafficking laws, but many fail to do so in spectacular ways, leading to unjust results. The persistent shortcomings in the various states' anti-trafficking laws here in the United States create challenges in our midst. And there's no doubt that the ULC's work on human trafficking has done a service to the overarching goal of holding traffickers accountable, providing critical support to victims in the United States and across state jurisdictions. And our invited speakers this morning will guide us through the ULC's work generally and specifically on trafficking. So the first session today focuses specifically on the contribution of the Uniform Law Commission and the resulting Uniform Act on Prevention of and Remedies for Human Trafficking, approved by the ULC and by the ABA House of Delegates 2 years ago in August of 2013. And we have materials down here and as well as upstairs and outside in case you want to have some takeaways to take in hard copy about this work and the Uniform Act. So we're pleased to have with us first Professor Anita Ramasastry, who brings a legal scholar's perspective to the work. Welcome back, first, Professor Ramasastry, to Notre Dame. Many of you will recognize her from the law school's spring symposium on business and human rights. Just some few months later, she's willing to make the trek across country to be here. Thank you. Professor Ramasastry is the current secretary and president-elect of the ULC. She was the vice chair of the drafting committee on the Uniform Act on the Prevention of and Remedies for Human Trafficking. Professor Ramasastry is a senior academic and expert in the fields of banking and commercial law, anti-corruption, business and human rights, as well as law and development. She currently is professor of law at the University of Washington School of Law, where she directs the Sustainable International Development Law graduate program. We also welcome Steve Wilborn, who brings an attorney-legislator's perspective to our subject. Steve Wilborn is the representative on the Uniform Law Commission from the state of Kentucky and is a life member of this commission. We are most fortunate to have him with us today as he served as the chair of the drafting committee on the Uniform Act on the Prevention of and Remedies for Human Trafficking. Mr. Wilborn's career has included the private practice of law, association management, elected and appointed government service. After establishing a small-town law practice, he was twice elected to the Kentucky House of Representatives. He then served as general counsel for the House leadership of the Kentucky General Assembly, and later as executive director of a major trade association. So please join me in welcoming these two speakers to Notre Dame Law School.
Good morning, everyone. Thank you very much, Christine, for that introduction, and it is nice to be back, and the weather is beautiful here, so it was lovely to come yesterday afternoon. It's Friday morning. You guys are students. The weekend is near, so hopefully we'll keep you awake and engaged this morning. We're here to talk about human trafficking, and I'm sure most of you, if you've ever even heard of the Uniform Law Commission, I mean, how many of you actually think about it on a daily basis? You're like, wow, Uniform Law Commission, really important, right? Yeah, no. It's sort of it's a lawyer's organization and kind of a well-kept secret. In the second panel, we'll talk a little bit more about the mechanics of the ULC and why we think it's important. I mean, he's a lifer, right? Life member, meaning, does that mean you can never leave?
Yes.
Okay. But the process...
I have no place else to go.
The process, why it's also important for the lives of many people in the United States, and so that's why I think it's great that we're talking about the role of the Uniform Law Commission, but looking at it through a problem that I think you and the journal have really spent time thinking about, which is human trafficking and the problem that exists right here at home in the United States with respect to trafficking, both sex trafficking, which you'll hear about from the keynote speaker, and then the rising awareness of labor trafficking, which exists even in the United States when we talk about different kinds of workers who've come in different ways. But I'm going to talk a little bit about how an organization like the Uniform Law Commission ever just even got involved with a project focused on human trafficking, right? As I mentioned, again, most law students don't think about the ULC because it doesn't really, fit into the law school curriculum, but you do at some point hear about the Uniform Commercial Code, correct? Like UCC and maybe Article 2 in contracts, right? So that's the way you think of it, like boring commercial law stuff, right? And the Uniform Law Commission is more than that. It is a group of lawyers, judges, and academics who are appointed by governors or legislators from the 50 states, the Virgin Islands, Puerto Rico, right? So, and the District of Columbia. So it's a quasi-political organization where you have people who are representing their state. So I represent the state of Washington. And we spend time drafting laws that are meant to promote the uniformity of law for the 50 states, right? So it's a kind of a federalism matter, which is to say that, yeah, certain things are the topic of federal legislation, but that states have an important role too. And so the UCC is a great example, right? It's like great that you only have to study one code in law school, right? You don't have to study 50 sales, right, rules. Article 2 is Article 2, right? And so that's great, even if you think it's boring. So it's really about figuring out when is it desirable for states to have the same law on the books to deal with a pressing issue. But I want to just say to you that the UCC is not the only thing that the Uniform Law Commission does, right? I mean, Commissioner Wilborn does not stick around just for the UCC, nor do I. Right? I mean, that would be pretty limiting. So we're there because we have an important role to play in areas like criminal law, family law, areas like trust and estates, human trafficking. I mean, there's business law, corporations, securities law. I mean, there's a lot of stuff going on. So how do we get involved with human trafficking? Well, I want you to think of the Uniform Law Commission, in addition to it being a well-kept secret, it's about drafting laws with kind of that, have anyone heard of the slow food movement? Right? Eat slowly, eat well, eat locally, but just, life shouldn't be about McDonald's and fast food. Enjoy it, right? So the Uniform Law Commission is like drafting legislation on a much slower and more contemplative method. So we have a process, and we have a committee that has a very antiquated name called the Committee on Scope and Program. It sounds like a secret society, but it's actually a very open committee of commissioners that meet and decide what kinds of projects should the Uniform Law Commission take on. Okay? And anyone in the U.S., or really anyone you could, submit a proposal to this committee saying, we think that this particular topic is right for a uniform law, that the 50 states really should, either because there's a lot of patchwork of laws, nothing's uniform, or because it's a new topic. So to give you an example, some of the things that the Uniform Law Commission is looking at now are things like drones, right? Drones are problems everywhere, or driverless cars, or Commissioner Wilborn's on a committee dealing with social media privacy, right? So just to give you an example of the fact that we deal with kind of issues of changing or pressing need. So the American Bar Association has a Center for Human Rights, and it has a project focusing on human trafficking. And LexisNexis, right, many of you know LexisNexis for different reasons, put together a proposal to the Uniform Law Commission saying, we think it's about time that there be a new state law on human trafficking. And the reasons given by the ABA Center and LexisNexis were varied. One, that there was a patchwork of laws across the states, right? Human trafficking isn't new. We have a comprehensive federal law, and we do have laws on the books, primarily criminal penalties at the state level, but many of those laws have been around for quite some time, and our understanding of what human trafficking is and the impact it has on victims has really changed. Right? So the ABA Center says that I think it's time for us to look at our state laws and to update them, to make them comprehensive, and most importantly, as Commissioner Wilborn is going to talk about, take a much more victim-centered approach to the issue of human trafficking. Because especially in the area of sex trafficking, as you're going to probably hear from Professor Levy, there's a real issue of, people who are forced into, prostitution being treated as criminals rather than as victims. And juveniles who find themselves, again, coerced into prostitution, again, being treated as criminals rather than as victims, right? So the question is how to really realize that people who are trafficking victims, right, who have been coerced and forced into something shouldn't be penalized for that. So one of the key motivations was this issue of, can we shift our policy framework to something different? The second was, can we deal with the patchwork and make everything uniform? Because trafficking, and we think of it as a process crime, is about moving people around and across borders, right? So if law enforcement is going to cooperate, right, isn't it better that we have the same laws on the books, right? Again, with some variation in different states to make it harder for a particular trafficker. Some of you may have heard about sort of on the news things like, again, juvenile sex trafficking taking place with traffickers using Craigslist, right, as a way of dealing with this. So you don't want traffickers to say, what's the best jurisdiction for me to exploit people in, because the laws are laxer there, right? So that's another reason. And so they came to us with this proposal, and the small committee that decides what projects we take on looked at it and said, yes, this is not normally what we do, right? So those lawyers who normally deal with the Uniform Commercial Code looked at this, though, and realized that, yeah, this is a pressing issue. And the Uniform Law Commission is not, right, we do tackle novel issues, but, we weren't dealing with trafficking on a daily basis, so it was about their persuading us not to just dive right in, right? The Uniform Law Commission doesn't just say, we're going to, today you give us a proposal, tomorrow we're going to start drafting a law. We have an intermediate process where we study things, right? So as I was saying, slow food, a long multi-course dinner, is that we have something called a study committee that's formed first. And a study committee never meets in person, but what it does instead is that it engages in a research and outreach to stakeholders, so people like prosecutors, defense attorneys, there are lots of organizations focusing on trafficking, advocates and others, to say, what should we be doing and is there actually a need, right? Someone's come to us and said, you should do this, but we need to actually double check and make sure we feel that there's a need. And if we spend 2 years drafting a law, that at the end there's at least some likelihood that we'll be successful in actually getting this enacted, right? I'm a professor. I could spend my life at meetings drafting model laws that never get enacted. That's great. It's just, more of my job security, right? But for the commissioners and for the commission, right, the proof really is in the success of the product, right? So we did have a study committee. I served on that just as a member. And after a year of studying, right, there's a proposal that's brought back to that committee that decides what projects we take on, saying, is it really good for us to do this? So after a year of studying, we actually decided that yes, the ABA's proposal was compelling, that they were right, that it was time to draft a next generation trafficking law, right, that we needed to go beyond just penalizing trafficking to doing much more. And so really this is about sort of the ULC in a role of updating and modernizing the law to reflect best practice and the work of others, right? So the Journal of Legislation, you guys probably talk about the fact that public policy is not about lawyers sitting around and saying, what's the best policy, right? So that we really needed to speak to psychologists, social scientists, others who could tell us, right, really what's the best way to deal with this issue beyond just the laws on the books. So that was our job, and I just wanted to underscore that unlike, Congress may sometimes have laws that never get enacted, right? So there may be log jams, right? And pending government shutdowns. But the way in which legislation is drafted at the federal level is very different from the way legislation is drafted through the Uniform Law Commission. We have 2 years of drafting, and our drafting committees involve and invite what are called observers, or really stakeholders, participants, to a very open process. Anyone who can come to the table is welcome to the table, and basically sits together to work on a collective draft, right? So it's a very different process, both in time and speed, and sometimes we're criticized for that. Like, how can you deal with social media privacy? Over 2 years, you're too slow. So that's something we can debate later, but it is a much more thorough process because you just sit around. You can imagine, Congress people have hearings, okay? We don't have hearings. We sit and we draft with the stakeholders at the table, reading the acts and basically deciding, together what would make sense for good policy and compromising with the people who will be affected by the act. So that's our process, and I'm going to hand it over to Commissioner Wilborn, who will talk really about the substance of the act and the product.
I was enjoying your presentation. If you want to just continue, it'd be fine. Thank you, Anita. And as far as I'm concerned, if you think of a question in the middle of me saying something, just stick up your hand or speak up and ask, and either one of us will be happy to try to respond to you. As Commissioner Ramasastry said, in 2011 the proposal came to the scoping program. And going back and doing a little research, we found that there were, at that time, 46 states had some type of human trafficking legislation. Now, that is a broad overstatement. In fact, what that ended up being is that, a couple of states had something that said that it was really more tied to prostitution. And so, although there were 46 states that had something, I think it would be safe to say that they didn't have much. And part of our hope was, as Anita mentioned, is that to determine, all right, it looks like this is a real problem, looks like somebody really ought to do something about it. The next question was, could we do something about it? Could we add value? And obviously, we're both a little prejudiced because we were directly involved in the process for 2 years then and several years since then. We think we've been able to. What we had over 90 observers during this process. Now, thank goodness, only 10 or 15 of them at a time, 20 maybe, actively participated sitting around this table, as Commissioner Ramasastry mentioned. But there were advocates, prosecutors, defense counsel. Anita was instrumental in getting some representatives of the business community to come in, because one of the things that we determined early on was that we thought it was important to criminalize the conduct of business entities that were actively involved in this criminal activity. That had not been done, and quite frankly, we were somewhat unsure whether we were going to be able to be successful. As it worked out, that ended up being one of the less controversial aspects of the legislation. So one never knows where one's going to end up. But all of these folks are brought together along with, and I forget now, 10 or 15 commissioners. And one of the things Anita was kind enough not to say is, of course, you have commissioners such as herself, and as you might imagine, if you have somebody with her credentials, it makes my being chair a lot easier. But there are also a lot of commissioners such as myself that are just small-town lawyers. And we have a system that allows this coming together of commissioners, some with no experience at all in any subject matter. That's where I fit in. And then some, such as Commissioner Ramasastry, who has experience in all sorts of things. But as you might imagine, neither one of us, nor did any of the other commissioners, had any real experience in human trafficking. If anything, we might have seen a blurb on TV on it, but we didn't know what it was either. So it's a bringing together of this divergent group of folks to learn together and then draft together. And I did want to point out, we always talk about that the advocates that we had there. One of the things that probably won't surprise some of you, not all the advocates agreed. And that was a rude awakening, because we had just assumed Polaris Project and others who were very instrumental for a number of years in promoting the legislative changes in the states, had some concepts. I went into it just assuming, well, everybody's not going to be on the same side there, and then we'll have some prosecutors over here who'll feel one way, and as an old defense counsel, I figured I'd be on the other side there. But what we found quite early on was that many of the advocates had different perceptions on how best to solve the problem. Fortunately, most of them came at it with, well, how can we best do this, not my way's the only way. So that was part of what we started with. The other thing was that obviously when we talk about uniform laws, normally what we're talking about is uniformity among the states. And that's still a very significant, obviously it's a part of our name, so it's a very significant part of what we're trying to do. One of the other things that I think we sometimes forget, and I quite frankly had forgotten it until I went back and was looking through some of our paperwork, one of the things that the ABA proposal and the LexisNexis proposal to scope and program first suggested was how important it was to develop a system where there was coordination within the state. And I think, quite frankly, that may be and may end up be one of the secrets to, it's not a secret, but one of the things that has helped us be successful. Because if you show why and how coordination within the state is important, so that the prosecutors and the police officers and the social service agencies are all working together, that is better for the victims and, even more importantly, for prevention moving forward, becoming aware. The other thing that it does is that system that then becomes operationally more effective is something that is easier to sell when you're talking to other states. So, unlike some of our other acts, and quite frankly, ideally we would have had it switched around like you all originally started out, where we talked about the Uniform Law Commission overall first, and then talk to us second. But we'll get to that after a while. So, what we were able to do over the 2-year period was bring folks together, develop policies and ideas that we could agree on, and then draft legislation that we believe would be enactable. That is one of the other differences, I guess, between what we do and what Commissioner Ramasastry was referring to. Model acts are, as you know, different groups will go out and they'll create what they consider the end-all, be-all to deal with this subject. I've participated in a lot of those and have always found them intellectually challenging, and really enjoyed it. Unfortunately, after I walked out of the meeting and felt really proud of how smart I'd been and how smart we were, the policy and the paper are still sitting on someone's shelf. They didn't come into fruition. The Uniform Law Commission takes the approach, we're going to try to give you the best bill drafted as possible. But then if we don't go out and get it adopted, and if it's not worthy of being adopted, we've failed. So over this 2-year process, and obviously we'll be happy to try to answer questions about how that worked, and my memory now is a little different probably than it would have been then in terms of who was helpful and who wasn't. But we were able to come up with, which is similar, I think, to probably what the protocols initially called for and all that, what we consider a 3-pronged approach. Commissioner Ramasastry was helpful helpful in a lot of ways, but one of the things that she was able to do in her position of leadership was to explain to our executives committee and whatever why this piece of legislation might need to be handled just a little differently than we handled some of the others. And part of that ties back into as we mentioned, 46 states already had something. We determined that we needed to, and I think you will probably have some handouts there, so I won't try to repeat everything, but we wanted to look to the 3 prongs were penalizing. In other words, we wanted to criminalize the conduct. We wanted to set up the other prong was protecting victims. And, that's where you get the affirmative defense and motion to vacate in the event that you've been charged with a crime and that type of thing. And then the third portion was, I think we referred to it in our brochure as planning and public awareness. I've always referred to it as promoting. Some people have not liked that because it sounds like we're talking about promoting human trafficking. But my idea was that we are promoting awareness. And that's where we get into the idea of the council and the coordination. And that is a significant portion in bringing about the ability to move toward the prevention. So we had the 3 prongs, and what we've been able to do is go to the states and say, and I can go through, we've got, we had 15 or 20 introductions in 2014 and about the same number in 2015, and we'll have more coming forward. But what those introductions in these various states, some developed or utilized the entire Uniform Act. Some took the prevention aspect of it. Some took the protection aspect of it. And what where we normally say, this is the Uniform Act, we want you to adopt the whole thing or nothing, Anita was able to convince our leadership and others that this was because of the status of the law, and because many states had, for example, criminal penalties, but they didn't have the prevention part. So why should we go in and say, look, if you're not going to do it with the perfect way that Anita and I drafted it, and it was just perfect, I'll have to tell you. If you're not going to adopt the perfect act verbatim, then don't do anything. Well, that was, first, it would have been pretty selfish on our part, and secondly, it was a realization on our part that where the Uniform Law Commission could be most helpful in moving our states and our country forward was to say, no, you pick what you need. Now, I'll have to admit to you, having traveled to North Dakota and Montana and Arizona, I think I was telling somebody I got to go to Arizona in August, and I got to go to North Dakota in December. So I won't tell you where Commissioner Ramasastry got to go to San Diego in the summer. I'm not going to get into that discussion. But each of those efforts, we go and say, here's what we have. We'll come and participate, we'll help, we'll assist you. But if you don't need, or you've got, or the legislative facts of life are, you can't get it all done right now, please take this part, incorporate it into your law, come back next year. And that's been the approach that we've used. And quite frankly, we've been, we're never satisfied. We would much prefer to have success beyond what we have. But we've been very successful, and so we're pleased that that's what's happened, and that's the approach that, because when Rich Cassidy, our president, comes and talks to you about the overview of how Uniform Law Commission normally works, that's not the way we normally sell what we do. But this was a very special case, and I think one that we are convinced was, in this particular case, the right way to do that. Did I end up touching on what?
Please, yes. I'll be very brief, and then we'd love to hear your questions. It's just, and again, many of you, as you go out into your careers, are going to find yourselves embroiled in the legislative process, either because you're working in the legislature, you're working in an administrative agency, or you're lobbying, or you're doing something where you want the law to change. So another thing that we have to think about in terms of drafting uniform laws is cost, right? So Steve mentioned, for example, the coordinating council. These things sound great, right? Shouldn't we get different government entities to work together? But we're always afraid of what's called a fiscal note, right? That when a legislation actually makes it to a state, and either a commissioner or an attorney general is actually advocating for a change in the law, they worry about what's called the fiscal note, right? That someone is saying that this particular piece of the law is going to cost more money, right? And so nobody, everyone's afraid, especially in today's financial climate, that if a law is expensive or has a fiscal note attached, it's just dead in the water. So we had to really struggle at different places about how to come up with cost-neutral ways to do that. For example, governors appointing existing staff to a coordinating council, not creating a new home for it, right? So those are things that they sound, things that sound good in practice, right, may still pose challenges. I just wanted to give you a couple of examples of how the law is sort of next generation. Commissioner Wilborn mentioned that we had these sort of three areas, or these three prongs in terms of the approach. But just to say that laws do change, right? So they do need, even if states had laws in the books, there were areas that we had to contend with. One of the most controversial was what we often refer to as the safe harbor, which is the idea that if you're under the age of majority, so you're a minor in a particular state, and you are arrested for prostitution, you are granted immunity under the law, right, that you cannot be convicted. And that was controversial for a variety of reasons. Some people say, well, are you decriminalizing prostitution? And fortunately, we had at the table, we have prosecutors from my state, which has been one of the first states to be actively involved in prosecution of trafficking, for decades. Is this idea that if you're a minor, just the theory that you can't consent to engage in prostitution. I mean, that there's a sort of larger policy issue that you are a victim. And so the safe harbor and the immunity provision was very controversial, although after we enacted our law at the federal level now, there are senators, including Senator McCaskill and others, who are promoting that same approach at the federal level. So that was controversial, and it was controversial for a couple reasons. One was the immunity issue, right? Were we doing something that was radical? But the second was that prosecutors say, hey, even for juveniles we know that are victimized, right? Unless we have the power to arrest them and detain them, we can't even get them and divert them into social services or to get them help. So you're taking away something that we have. And we had to deal with that belief among prosecutors and work out a way in which, these are children basically, can be diverted and provided services. So that was another was an area that we hadn't thought about until advocates told us about it, which is coercion, right? That coercion, if you think of criminal law, is typically about forcing somebody into something, right? Trafficking is about someone being threatened or forced into labor or sex trafficking through this kind of use of force or intimidation. Well, we were really educated. I mean, again, the drafting process is educational for everyone about what is different. And that there are many new kinds of coercion, right? Getting people addicted to drugs, right? If you get someone dependent on drugs as a trafficker and that person is now impaired, that can be coercion. Taking away someone's immigration papers, right, and locking them up can be coercion. But the one that we grappled with the most, because it was new to us, was this issue of taking advantage of someone with a mental disability, right? That if someone is a vulnerable person because they lack the certain type of mental capacity, there's actually no force involved, right? This just involves actually someone being taken advantage of in a particular way because they don't have the capacity to understand that what they're being asked to do is trafficking. And so we really struggle with that, both as a policy, but also how to even draft effectively and respectfully around that issue of an expanded definition of coercion. So those are the kinds of things that we had to grapple with. And as Steve mentioned, really one of the most controversial areas among the advocates, and it was one where, again, our charge as a committee was to focus on trafficking, right? The people who were forced into some type of servitude without their consent. But there are advocates there who also thought that our law should be about penalizing people who patronize prostitutes, right? That there was a set of advocates who believed that any type of prostitution, so we're not talking about minors now. Our act provides immunity for minors who might be engaged in prostitution, right? Without having to engage further in were they trafficked or not, right? That was a policy statement. But when it comes to adults, right, there were advocates who were passionate in saying there is no such thing as voluntary prostitution, right? And so they wanted our act to say that anyone who patronizes a prostitute should be convicted of a felony crime. And actually some states are now actually ratcheting up their penalties for patrons. The issue for us was just the fact that, the charge of our committee was to focus on trafficking. It wasn't an anti-prostitution statute. And also that we had to struggle with this notion that at the end of the day, our act did have to be enactable, right? So we had to deal with that. So there were definitely lines that we couldn't cross, but there were, people pushing hard for those policy outcomes. And again, our job is to sort of mediate between all of these different views to come up with something that we think is as strong and as enactable as it can be. So I'll just stop there to say that gives you some of the flavor of, there really are these tense and strong debates about what is the right answer. And with everyone there believing that this was a problem. And the last thing, and I know that we have Aaron here who wrote a note on the piece, which is that there is much more of a focus in the United States on sex trafficking. The piece that's the hidden one, which we started to look at and try to deal with, was labor trafficking. And so I'm glad that we did. And as you can open the New York Times and hear about people who are working in the nail salons and other things that's something that we haven't yet begun to grapple with. And so I'm glad that our act was able to also address that problem as well. Thanks. Aaron.
Issue like this where there's already a fairly strong federal law and most of
Well, one jumps in somewhat gingerly. I believe I'm correct that the 2000 protocol or whatever actually suggested, required something that, and there was a model act or something that for the states to adopt, which was less than successful. So obviously there was the thought process going in, even with the federal act, that it was important for the states to do something. As I mentioned, we normally, if a project comes to Uniform Law Commission and the states are already dealing with it, even though they may be dealing with it in slightly different ways, we don't deal with it. This was one because of that which was on the books was, as I think I mentioned, there were 46 states that had something. But once the research was done in terms of what that something was, I think it would be safe to say that it was not only was all across the board, but it was not in very much depth. It was almost always dealing a little something about prostitution and maybe adding something there. There was not much substance to the substance. So that allowed us to believe, based and with the ABA and others coming in to promote it, that we could have some value added, and that's why we took the next step of at least trying to see if we could be successful. Yes. Okay, we're going to let the gentleman in the front row. Okay.
So, two questions. First of all, but you just take the first one. As far as there are already laws in the books in a lot of states, as a federal law, kind of jumping off your question, where do you see the major gaps in the law that motivate you to go and write legislation and push for it? Like, where are we failing across the board?
And the points are, and if we look at the different, it's really in the protect and sort of the middle category. So there are a couple different things. One is that in the criminal law area, there were some states who had very little in the book. So we still knew that we needed to have a comprehensive act to address in the criminal area states that didn't have anything, and also to update, right? That, as I mentioned, coercion, we have a much broader and better understanding now of how traffickers coerce. So even for states that have had laws, right, you'd see that the definition of coercion would be very limited, or business entity liability wouldn't be on the books. So you could get a person, but you couldn't get, if a motel was running a trafficking operation, you couldn't get the salon or the motel. So it's those kind of things where you could see that even the criminal law, which is really where states began, right, was outmoded. It was really in this area of the victim protections that there really wasn't anything, because that's really new, right? So the idea, again, that minors should be treated differently, that there should be a chance, if you've been trafficked, and again, if you're a trafficking victim because of the fear that you have, if you're arrested for prostitution or you're picked up for not having papers as a migrant worker, you may just plead guilty, right, and just wait to get out, but you're now penalized even though you've been coerced into something. So we now provide both an affirmative defense. If you're actually tried, you can raise the fact that you're trafficked at your trial, but you can also seek to vacate those prior convictions, right? So it's those types of things that are new, and having access to certain kinds of services. And then I think, as Commissioner Wilborn mentioned, the coordination piece was also important as well. So I think it's those latter two prongs that were really new, and so we don't go to a state and say, if you already have it, take it, right? We say, let's look at your law and where is it absent, what's missing.
I think the other thing, I know the worst thing to always do is, as young people say, well, this is, well, if I was young and all that. Quite frankly, in 2011, you all may not remember this, but I do. 46 states had something, but the awareness across the country of human trafficking, of sexual servitude, or whatever, it was non-existent.
Or just that it was it was a problem overseas somewhere.
It was a problem overseas. It was in Sydney, Australia. It wasn't in Simpsonville, Kentucky. So I think we also felt, and this is looking back on it now, that we could be a part of the new wave of creating awareness both within our organization and nationally. And, quite frankly, that's been the case. Now, I don't know which came first. I have a feeling that the awareness of the news media and the TV programs and whatever probably didn't fall just because Anita and I participated in drafting an act. But what has happened is that small steps by individuals, built into smaller steps by groups, which built into larger steps. And so I can remember, and I probably shouldn't tell the story, but I can remember one of the first meetings that we had after we had worked on this project, and we have a process which will be discussed later on where we read our acts line by line in front of 350 lawyers. Well, first 350 lawyers, you got to imagine what that's like. And, you have as I say, you have the small town lawyers like myself, and you've got the law professors, and you've got federal judges, and you've got, all sorts of groups. They all feel that they know the answer, and that their answer is the only answer. But I can remember us talking about the act and explaining it. And one of the old liberal war horses of our organization, who shall remain nameless, but who has been in the forefront of every civil rights action fight in the Northeast that you get, stood up and said, "We know it, this is nice, but there's no human trafficking in my state." So, now I can assure you that he knows and doesn't feel that way now. But I think that was one of the other reasons that we decided that this was something that we should undertake, was that we could be a part of building the awareness among our own members and their communities and their states in a way that would be positive in the long run. And I think that's been the case.
And we have a long way to go. I mean, I think the main thing, the other question was like, well, you've got a federal law. The feds have a finite amount of resources to deal with this, and so we need state prosecutions. And if you look at the statistics, there's been very little at the state level. So we have a really long way to go. The enabling legislation is great, but implementation of the laws is really going to be the next decade. Because most states, again, weren't aware that there was a problem, and now slowly are stepping up to say, okay, yeah, it's here.
So my understanding of trafficking is that within the United States, for instance, there are certain hubs where it occurs more than others. And it would seem to me that one of the benefits of not having a uniform code is that resources can then be dedicated to said hubs, as opposed to allocating resources to places where trafficking isn't happening as much. How do you feel that enacting a uniform code would actually not do that disservice?
Well, I should ask you a question back. When you're referring to hubs, are you focusing more on labor trafficking as opposed to sex trafficking?
I'm thinking more of sex trafficking.
Okay.
But
Well, I mean, I think the resource issue is one of just the laws are, the laws are just laws, right? The resource allocation is a question for each state, right? So we're just saying have uniform penalties on the books so that if a trafficker either is in a state or crosses state lines, let's say, with a person, that they're going to receive the same penalties, right? So it's about creating a way in which you can't seek the lowest state, right? The state with the least penalties. And to some extent, the prosecutors were able to share with us their own evidence in terms of, I mentioned Craigslist, of where the law is laxer, right? People who, again, you can be quite smart, right, if you engage in criminal enterprise, right? So part of that is the regulatory arbitrage, right? And so I think that's the concern. Your separate question, which is that if there's a more intense problem here, right, why would you need something here? That's a resource question, and we don't get involved in the issue of how you spend the money to fight the problem once you have the laws.
Well, let me push back just a little. I think it's true that when you have the Super Bowl in Indianapolis, there's, one would assume, and I know, you know, the legislature here tried to deal with it, whatever, when they have the Kentucky Derby, there is an influx of folks who I think we feel pretty strongly that are both human trafficking and sexual servitude, whatever. But when I traveled out to North Dakota and Montana, they've got there's I forget the name, oil fields out there that they didn't have 4 years ago. Now the size of what's going on there is overwhelming the states. So I think the idea of creating legislation or having on the books policies which both criminalize conduct but also are there to help coordinate within the state and whatever is the type of thing that one does and needs to do, and you don't look at it's not the type of thing that you say, well, the problem is here. So I think I might respectfully disagree in terms of whether it is a problem that is focused in a particular area at a particular time. And I'm not restating your thing exactly right. But the wisdom is to have in place the laws and the protections and the procedures such that if it's a major event or if it's one person in a nail salon or one young boy or young girl on the street, we have the ability to capture and help in that situation. Yes, ma'am.
When you were talking about protection for minors in prostitution, I was wondering if that extends to people who enter the prostitution trade as a minor and they're charged as an adult.
So in terms of, we dealt with that in the sense that the actions, it's just an age, so we use the age, right? So the age is the cutoff, and so the question is at the time in which you were either apprehended or arrested, if you were a minor at that time, even if, you know, as you're waiting, time passes and you become an adult, then the safe harbor kicks in. So the issue, though, of can you be charged as an adult, the idea was we just use the age, right? So if you are a minor legally in that state, and I'm just trying to think now, did we bracket the age?
Well,
no, I think, I'm sorry, I didn't understand your question at first, which is that what I'm trying to figure out is whether we used a cutoff of an age, and this is sort of showing my faulty memory, or whether we did leave it to the states to decide the age of the minor.
Well, I think you have to, every state by its regular laws determines who a minor is. Now, in most cases, that's, you know.
Most cases it's 18, but not in every state, yes.
So I think the motion to vacate also ties in there, and that, of course, that's, as we would say, after the fact. But that was the importance there, because you have men and women whose conduct was caused at a certain, you know, by their being victims. When they're finally able to get out, all this history carried with them, and I was impressed by some of the defense folks that we had with us that talked about clients of theirs who did the heavy lifting to get out and to fight and to testify against, but yet there was no place for them to go, because here's this history that says that you were a prostitute and you stole this and you did that, and so the motion to vacate is a bridge in that type of situation.
Yeah, but your point raises that, which is that as uniform as our acts can be, there will be variations in the sense that we do have to defer at times to state law. So who is a minor in one state versus another is going to differ, so that the immunity provision won't be as uniform as one would like in terms of 18 versus 16 in a state.
What's one thing that over the 2 or 3 year process of research and drafting, was one thing surprising that you learned, or was one unanticipated challenge or concern that was raised that you didn't see going into the process?
Well, the surprise, I mean, again, so I think the advocates and sort of the fact that they weren't on the same page was a surprise, and the fact that, again, the way in which the anti-prostitution debate bleeds into the trafficking was, it was more intense than I realized. But for me, that coercion was one, right, where, it really took all these other people having to educate commissioners about this. And there was a case, unfortunately, it was in the Midwest, of a particular turkey farm where men who were intellectually disabled, right, had basically been forced and had been living basically in prison, working in a poultry farm for decades, right? And and the EEOC, rather than criminal prosecutors, actually brought a case to have them at least, freed and to seek restitution. So, and the EEOC deals with discrimination, right? Doesn't deal with criminal penalties. But when that particular turkey farm case was publicized during the course of our drafting, it really clearly showed to me that coercion is this broad issue, right? That these men didn't know they'd been trafficked, right? They were just basically living in these deplorable conditions and going off to help process turkeys, paid nothing, essentially, because that's what they thought they were meant to do. So that was surprising for me.
Well, I absolutely, the fact of the very vehement's probably not the right word, but the very significant differences of opinion among the advocates on several issues caught me somewhat unaware. But the other thing, and this is on the positive side of it, I quite frankly assumed that the business entity liability that we were putting in the Act was going to be, we were going to be fighting it from day one, and that the big companies are going to come in and just beat us around the head and neck, and the truth of the matter is, of course, we were able to bring some of those folks in to help us word it in a way that we didn't have unintended consequences. But quite frankly, I don't know that we've had any opposition from the business community to our efforts. And in fact,
and we'll mention, you'll hear from, and our president has just arrived, Rich Cassidy, but you'll hear from him a little bit later about the process and the involvement of the ABA, because there's another step where the American Bar Association looks at our acts too. So we were surprised, right? There was no corporate backlash.
Yes, young lady. Are you a student here?
Do you need glasses? So this issue of transparency in supply chains, and I know there's a California Transparency in Supply Chain Act. Did you think about, or maybe I missed it, think about putting something in that gives businesses some responsibility to look into?
Yeah, and so there was some, I'll speak to that because that gets into sort of another area that's attempting to deal with labor trafficking, but trafficking globally, right? So more about American companies and trying to get them to have better practices so that the things they sell us aren't made by children or by people who were trafficked, right? So the California Act, many of you are familiar with it, but some of you may not be, is a law that California has that says that if you're a company, and California is such a huge economy that it really covers most major companies in the U.S. or globally many, you have to put on your website, you have to answer a series of questions on your website about what you're doing. So like Apple or Google, whatever, what are you doing to figure out if anything that you're selling is made with child labor or trafficked? And the thing about the act and why it probably passed in California was that it's called the Supply Chain Transparency Act, which just means that the minimum thing you can do is your company can post a notice on your website saying we do nothing, right? We're a small business maybe, right? So if we're a small company in California, we don't deal with the international market. We can say we don't do anything because we're too small. But you can also be a big company and say we don't do anything, right? So the Act doesn't require companies to do anything more than they're already doing, just to answer questions about whether they're looking or not. Is Nike looking? Is Apple looking? The theory being, though, that if you have to disclose whether you have practices and policies, right, that consumers and public pressure will make companies behave better, right, that Apple will clean up its supply chain in China, right? We talked about it, right, but our focus really was on the issue of domestic U.S. trafficking and protecting victims here. So we realized that was a sort of, a different generation of act, and that might be something for a future project, that people may come to us.
I know that recently a lot of states have been pushing towards raising minimum wages, and I was just curious if there's been any discussion of that having an effect on demand for human trafficking, specifically with respect to forced labor.
No, it's an interesting question.
I've not, in my travels to various states and contact with, the issue has not been raised. It's an interesting point, but it's not something I've heard or that has been proposed or suggested as a problem one way or the other. Anyone else? You're going to try again, huh?
In drafting a uniform code on this, is there any state or jurisdiction in which you find the rules to be satisfactory enough to model around?
Yeah, or I can tell you about a state that's not going to enact the Uniform Act, mine. Because essentially, we had everything before the Uniform Act was drafted. Washington State, just because we were one of the very first states to put any laws on the books, and we've continuously updated our laws and shifted our policy focus. So we won't, yeah.
And I think there are, I talked about Kentucky, for example. We had a state representative down there who was in the forefront of brought a group together and spent, quite frankly, a year or two of getting police officers and advocates together, and they utilized, I think, a lot of the Polaris Project concepts, which is, you could see many of those flowing through our act. So when I went to, some of the commissioners from Kentucky went to look at our act, we said, well, look, these three parts are, quite frankly, you could have used our wording or their wording, it's the same thing. So we didn't go in and say, look, here we are, we're the government, we're here to help you, let's do this. We said, we found, as Anita mentioned, that there's 2 or 3 parts here where you all have gone this far, would you look at doing this? And here's how it ties into what you've already done. We've been very fortunate to approach it in that way. Yes?
So I think you both mentioned toward the beginning of your remarks that when your role within the Uniform Law Commission, originally you never foresaw that you would be tackling an issue like human trafficking. But lo and behold, it was brought to you and you felt like that was something that was obviously worth looking into and putting the time and effort into. So having not been the expert in the area and going through the process of years of research and things like that, what resources did you look to educate yourselves and to inform the process when you discovered things like coercion were an issue? What resources were you looking to educate yourselves and to be able to be in a position to get something out there that would be attractive to the states?
Well, there's a couple of things, and I'll just talk about, well, one of the things we didn't mention is that another person who helps guide the process is somebody called a reporter. And a reporter is usually an academic, doesn't have to be, but it's someone who has some substantive expertise, and they basically are the ones that are taking in everything that they hear in drafting committee sessions from commissioners and from experts, and then producing a draft and commentary to help guide the process. So we had a professor from Georgetown who runs a women's human rights clinic who was the reporter. So that's one place where they're meant to provide some research and guidance. but it really is from the observers, right? That the Polaris Project was sitting at the table, a representative of the National Association of Attorneys General, people that are really dealing with this issue. And so not only will they bring their expertise to the drafting process, but they will submit materials and suggest people that we should speak to, engage with. So, we talked with the question about, well, isn't the federal law enough? We spent time on the phone with federal prosecutors figuring out what they were prosecuting, what they weren't prosecuting, and where the gaps were. So, by the end of the process, in terms of reading and submissions.
Well, no, I think you captured it all, and that is, and our president, I'm sure will tell you, among other things, that's part of the beauty of our process, is that you take those of us who have no expertise in the field, and our process doesn't make us experts, but it allows us to bring together a product that benefits from both the expertise in the field, but then the expertise in day-to-day practice. I'm always amazed when I participate in the uniform either drafting process or the process where we debate on the floor among, as I mentioned, the 350 attorneys or whatever. Invariably, you'll have a committee, and it happened to us, and we'd be sitting there, and we were, by the time you've done it for a year or two, you do begin to sit up a little taller in your chair because you know that you know, even though you're pretty sure they don't know. And invariably, some person will stand up and ask a question who has no experience in human trafficking or anything that none of the rest of us thought of. And that's I think that's one of the beauties of our process, is that we take from all to develop a product that is better than any one of us could put together, or even any one group of experts. So I'm rambling a little, but that's I think, and I'm sure President Cassidy may well address that among other things.
I think the gentleman there.
Yeah, I don't want to get too far into the nuts and bolts of it because we've been asking a lot of general questions. But my question, I guess, is about sort of the advocacy. I saw in the uniform law a provision for restitution and forfeiture to try to address. What we've seen is a lot of really inflexible supply chain. So I think that you mentioned the Polaris project. A lot of other NGOs that this end-demand strategy is, I think, very prevalent in the uniform code, or the uniform law here. And I guess my question is, do you think that the restitution provision, the forfeiture provision, which I guess would be tacked onto traffickers, sometimes they blame, sometimes they don't. I mean, we're talking about traditional forms of prostitution in the U.S., which we look at as trafficking now. A lot of them don't have access. A lot of them don't have anything that they can really provide to the victims. And so I guess the question is, do you think that these provisions are enough, or is it the addition of a civil action, as you guys have in here as well, or the council for human trafficking for each state that helps address some of the inflexibility in the supply chain, meaning that there's not a lot of times there's a lack of legal exit for trafficking victims, right? So even if a trafficker does get punished and you're deterring the demand, sort of the supply chain a lot of times doesn't respond to that.
Okay, yeah, and again, you're speaking and using terminology a little bit different than the way we would. I would say, and it's interesting that you think that the act is very much an end-demand act, because from our perspective, we really pushed back. I mean, not that it's not again about what we personally think. It was about what we thought was enactable. It was about hearing what were the best ways. And when I hear end-demand, it's really about the issue of penalties for people who are engaged on the demand side, right? Because demand is about the patron or the consumer or that, right? But you're right saying there's a deterrence feature, right? So and so you're speaking about the trafficker and and the supply chain, right? How do you make it less attractive for people to think that this is something that they should do? And there are multiple things in there. So the civil action is allowing victims, right, to sue their trafficker. And the reason that that's in there, a couple different, right, that is a next generation policy issue, but it also is because very often, again, when states have limited resources, you'll have attorneys or you'll have what are called advocates, right? They are people who work for NGOs helping advocate for trafficking victims. If, for whatever reason, a prosecution is not possible, right, because we can't, if I'm a victim, I can't make a prosecutor prosecute, right? They have to decide and have the resources to do it. The civil action may be another way to address the issue, right? So it's more about providing a multiplicity of tools. In terms of restitution, it's the same thing. And you're right in saying if the resources aren't there, then a court can order restitution, but there won't be any. So I'm not sure I understood your restitution piece. You're saying, do we think it's going to help address that inflexibility? Is that?
The question would be that whether or not the restitution and forfeiture provisions plus the civil action would be enough to really address that inflexibility.
Yeah, and I don't think anyone thought they were enough. I think they just sort of thought that there needed to be a multiplicity of tools. So the sort of the fact that since prosecutions may or may not occur, we needed the civil penalty. The restitution was there, again, if there is money, and we spoke to people. There's a professor who runs a clinic at the University of Michigan, right? Very successful with respect to restitution orders, right? So again, maybe an individual trafficker, but if someone runs a strip club, there may be money there, right? So that's all. So I just see it as a multiplicity, but I don't think we thought anything particular. Asset forfeiture was a little more controversial, right, in terms of that. And so as a result, it's bracketed, which means that it's an option for states, but it's something that they don't have to take because it does bleed over into that larger debate around civil liberties and forfeiture.
All right, I'm going to cut you guys off, but we're on schedule for a 15-minute break before we have the next panel on the uniform laws. So we'll be back here at 10:30.